afternoon. Good afternoon, everybody.
Good afternoon, ma'am.
You know, we had a training in Abuja. So I just logged in to just wish you all the best in the discussion and just register my presence for a short while because I have to
Good afternoon, everyone.
The training.
Good afternoon.
I just want to charge Rivers Chapter that I would really love a situation whereby we will bring the training to Rivers State next year. I look forward to getting like 30 applications from Rivers State and its environment so that the fast track training can actually
Yes.
Thank you very much, Rivers Chapter. You are doing well. I wish you all
Thank you, ma. Thank you, ma. I
would love to have a recording of the discussion so that I can look at it during my own spare time.
Okay, ma.
The conversation is ongoing. Everybody's talking about CAMA now.
Yes.
I really want to hear your participants and our discussion. Thank you very much.
Thank you, ma. We'll ensure that we get it, ma.
Okay, yes, thank you. Bye.
Thank you.
Hello, Madam Committee Chairman.
Okay, a very good afternoon to everyone. Welcome, our dear participants. I hope you can all hear me. This is the Institute of Chartered Secretaries and Administrators of Nigeria, Rivers State Chapter. We warmly welcome you to our September 2020 webinar, themed CAMA 2020, Innovations, Intrigues, and Downsides. The webinar has officially commenced, so I will proceed to give us some ground rules. Please listen attentively. We urge all participants to kindly put their microphones on mute to avoid distracting proceedings. We also request that, that all participants, as you come in, ensure your mic is on mute. The webinar is going to ensue in the form of an interview-style discussion. So what this means in essence is the panel moderator will direct questions to the panelists, and then they'll give responses on the CAMA 2020 legislation. So for the purpose of ease of use of this webinar, only the moderator and the panelists will have their microphones on. Now the chat section is enabled. So what it means is everyone, the participants can put their comments and their questions for panelists in the chat section of the Zoom app. There's a portion for Q&A in the course of these proceedings. When we get to that point, all questions put forward by participants will be responded to by our panelists. Now, in the event that some questions put forward by participants cannot be taken in the course of this webinar, we're going to send the responses to the registered emails of all participants who have registered for this webinar. The other information we need to be aware of is there was a CAMA quiz which was sent out to participants yesterday. So we're going to have an announcement of the winners of the CAMA quiz. And then the webinar is going to be streamed live on YouTube. So participants can join the session live. Now I'm going to go forward to give us an outline of the webinar presentation for today. The webinar will kick off officially with the chapter chairman's opening remarks, and then we'll move straight into introduction of moderator and panelists. And then the discussions on the CAMA 2020 will kick off immediately. Subsequently, we'll have the Q&A session and then announcement of the winners of the CAMA quiz. I will move swiftly into the votes of thanks. So at this point, I want to invite our chapter chairman, Barrister Emeka Onoha, to give us the opening remarks. Barrister Emeka, please.
Yes. Thank you, my chairman. Good afternoon, everybody. I want to welcome you all to everybody to our September webinar of the Institute of Chartered Secretaries and Administrators of Nigeria, Rivers State Chapter. My name is Barrister Emeka Onoha. I am a member of the Institute and I have the privilege of serving presently as the chairman of the chapter in Rivers State. I am most delighted to you to this webinar titled Innovations. The Institute of Chartered practice of corporate governance, corporate secretary. We are the ones that train and qualify chartered secretaries, chartered governance professionals, by law in Nigeria. It's statutorily authorized. So our headquarters is in Lagos, and in Nigeria, the institute is an offshoot of the International Professional Body of Chartered Secretaries / Governance Professionals with headquarters in London. ICSAN Rivers Chapter is made up of 4 states. Rivers, Bayelsa, Imo State, and Abia comprise the Rivers State Chapter. Part of our responsibility as an institute, whom as a chapter, is to train and educate both members and the public. Our training includes commercial, professionals, and as a corporate social responsibility, just as we are doing today. Our seminar today is unique, particularly the topic, because of what it portends to the business and economic environment in Nigeria. That is the introduction of CAMA, 2020, which is an amendment of the previous one. Today we have assembled the best materials in terms of experts and professionals to divulge what you need to know about this new CAMA 2020. And so I urge you, everybody who has joined us today, to sit back, relax, you will enjoy yourself, and you are going to listen to have sound. Now, you have not heard from ICSAN about the new CAMA. Please don't conclude yet. Today, the Rivers Chapter is presenting you the opportunity to get the details of the intrigues, the innovations. It is on this premise that I want to thank you for joining us already. I assure you that you will enjoy today's program. Sit back as I hand over to the moderator of today's program, in the person of our General Secretary, Sir Sebastian Essien, who will conduct the proceedings, and I assure you that is worth your time. Thank you very much. My able General Secretary, over to you, sir.
Thank you very much, Chapter Chairman, and good afternoon, our audience. Thank you for joining today's very, very exciting event. I'm going to go straight to introduce members of our very distinguished panel who will do justice to the topic for today's event, which is CAMA 2020 Innovations, Intrigues, and Downsides. I'm going to start by introducing our first panelist, in the person of Mrs. Otade Akiamen. Mrs. Omosade is a lawyer, a charter secretary, and a professional mediator. Presently, she works as a litigation lawyer in a reputable firm in Port Harcourt, where she functions as the head of chambers. She graduated from the University of Benin with honors and went ahead where she graduated with a second-class degree in law with an ardent focus on corporate law, business law, labor law, and international law. She is incredibly passionate about corporate governance and effective corporate administration, and strongly believes in the substructure of any credible organization. You're welcome.
Thank you very much. Glad to be here.
Our next panelist is Dr. Pelowe Subai. Dr. Subai is a legal practitioner and a senior lecturer in the Faculty of Law of the Niger Delta University. He holds a PhD from the Newcastle University and has research interests in company law, competition law, as well as energy and natural resources law. He is the author of the seminar book titled Local Content Oil and Gas Law in Africa, Lessons from Nigeria and Beyond. He has taught company law for 2 decades and has published widely on the subject in local and international journals. Dr. Subai, you're welcome. Our next caller is no other than Mr. Yes, is a legal practitioner and is currently the legal manager, corporate services in INTRIGUES, Nigeria.
Good afternoon, everyone. Thank you for having me here.
Our fourth and final panelist is no other than Mr. Soji Militarian. Mr. Militarian is a partner at a family law partnership in terms of barristers and solicitors and one of the leading commercial law firms in Port Harcourt. His practice areas are mainly commercial, company and property law, and company secretarial. Mr. Soji, welcome to this session.
Good afternoon, all. Thank you for having me.
All right.
Thank you, sir.
Okay, we'll proceed as soon as we get confirmation that the supervisor will let you know accordingly. The next story of the business of the day, the review and requirement of CAMA 1990 as CAMA 2020 is a major game changer in the corporate regulatory landscape. The bill was signed into law by the President of Nigeria on the 7th of August 2020. I want to start from Mr. Soji. One of the overriding objectives of CAMA 2020 legislation is to enhance the ease of doing business in Nigeria. To what extent does the legislation achieve this objective? Mr. Soji?
Thank you so much. Good afternoon, everybody. Yes, like the moderator has just said, CAMA was just introduced, just passed into law on the 7th of August 2020. The last major amendment, as we know, or reform as we know, was in 2004, so rather commendably, we have it now. The Act, which had 4 parts, now has exactly 7 parts, A to B.
Yes, come in.
Additional 258 sections and some existing sections were amended or modified. Some were removed. Some of the innovations include the right of one person to form a private limited company, partnerships, Part C, limited partnership, Part D. Authorized minimum share capital for private companies have now been reduced to 100,000 as in Section 27 of CAMA 2020. Fees payable for the registration of charges have been reduced to 0.35% of the value of the charge. Section 240 of CAMA permits the holding of general meetings virtually in line with the Articles and Association. The appointment of company secretaries is now more mandatory. It's no more mandatory for small companies. That's under Section 330 of CAMA. Section 394 has changed the requirement for qualification as a small company accordingly. A small company shall be one with turnover between 2 million to 120 million and asset value from an amount between 1 million to 60 million. Small limited companies or companies that have not done business since incorporation are exempted from filing its audited account. That's Section 403. Section 851 sets up a 7-man administrative committee with powers to hear, resolve, analyze for contravention of the provisions of the Act or its regulations. A very interesting provision, I must say. Now, to relate this to the chant, or should I say the talk of ease of doing business, I think it's necessary we look a bit at what ease of doing business is essentially about. Historically, ease of doing business flows from the Doing Business Project, started in 2002, essentially to objectively measure business regulations and their enforcement across about 190 economies. And their results are published annually by the World Bank Group. To determine the ease of doing business in a country, countries are ranked against one another based on how friendly or conducive the regulatory environment is to business operations. Doing business project motivates countries towards competitive and more efficient regulation, offers measurable benchmarks for reforms, and provides valuable resources for investors, researchers, and other interested parties in the economic climate of each country. And to determine ease of doing business, index, the following 10 items are considered. Starting business, 2, dealing with construction permits, getting electricity, registering property, getting credits, protecting investors, paying taxes, trading across borders, enforcing contracts, resolving insolvency. Nigeria is presently ranked 130 among 190 economies in the Ease of Doing Business Index annual rating. It's actually up about 15 places from its 2019 position. These evaluations are essentially directed mainly at timing, costs, and procedures. That's to say how fast you're able to conclude a transaction in the country, how quickly you're able to do your business, register, and get going, the costs involved, and how tedious and how long the procedures are. CAMA 2020 in this regard directly covers about 3 of the mentioned aspects, mainly starting business, and to some degree protecting investors, enforcing contracts, and resolving insolvency. Now, indeed, in a way, this amendment of CAMA actually could be seen as one of the achievements of the Presidential Enabling Business Environment Council, which under the Buhari administration has a lot of other initiatives in place. Now, the problems with this ease of doing business indices is so apparent in when you look at those 10 items. How they determine those things actually is some kind of a rating process where marks are given, for example, for procedures. For Nigeria right now, it is on their website that procedures for setting up your business, for example, you have just 7 procedures. And the time for you to set up a new business is just 7 days. And it is put that the cost is so minimal. Indeed, we believe the bases used are too vague, minimalistic, and not reflective of extant realities. The results are not based on nationwide statistics. For example, the 2020 results are based on statistics from Kano and Lagos. Of course, the percentage of the country that constitutes is very apparent to us. And in arriving at their results, in considering time required for starting a business, it said that one could register a business in about 7 days. That's to say from reservation and availability to when you get your certificate is 7 days. That's hard to believe. In determining length of procedure, a procedure completed online is actually, by their own calculation, considered as a procedure done on half a day. Now, if you put that side by side with the glitches we see in online transactions, it's hard to rely on such methods. And in considering costs, only official costs are considered, excluding professional fees and other known and avoidable costs. Known and unavoidable costs. That's why actually you can go on the CAC website. You see a list of how much you're supposed to pay for any item, any transaction there. And it's taken that that's it. Meanwhile, the CAC has its own unilateral methods of, continuing to ask for more money and creating more procedural glitches. Now, our reality indeed, the new law has actually created a broader playing field under Part C and D, allowing for companies with a single shareholder to encourage entrepreneurship. Quite commendably, a lot of the talk about entrepreneurship right now will be seen as achievable, considering that you don't need so many shareholders, you don't need such reporting responsibilities. Fantastic. But on the other hand, the procedural bottlenecks increased costs and timing just created and deployed at the CAC actually makes the talk about ease of doing business mere sloganeering. It's not true that an entity can be registered in an average of 7 days from availability to getting your certificates. Right now, as we speak, there are courier companies whose method of pre-qualification is so opaque, unknown, and they're not professional. They just receive and deliver documents at the way and methods they like. Problems created by all of that include, yes, sir.
When we get to we've really said so much about the issues around the ease of doing business and the extent to which that's supposed to be.
Yeah, my respectful position. Hello, sir. My respectful position is that indeed, the act as it is has very commendable objectives, but in implementation, it will look as if what is given by the right hand is taken by the left hand. Indeed, by the end of August.
Okay, almost at the let me get to almost at the this is almost at the I can't remember. Do you agree with this position? Regarding the issue of the benefits of this legislation, the newly enacted CAMA. What is your take on this?
Thank you very much, Sir Sebastian. To an extent, I would agree, but I'll also say something. A cursory analysis of this CAMA 2020 can be seen that it also tries to reduce. If you take a glance at the sections, it can be seen that it is more targeted to small and medium-sized companies, and also to remove barriers that emanate when registering a company. For example, there are some salient provisions that have been entrenched in this CAMA with regards to the ease of doing business. The single member company that was mentioned by Sasojie, and by including that in the CAMA, it has given entrepreneurs who were wary or who were not really, they fear registration of companies, giving them a path to come into incorporations of their company. And as a single member company, you enjoy several benefits, such as the fact that you are not mandated to hold your AGMs, you are not mandated to appoint an auditor, a secretary, and as well as all of that. All these have been done to reduce the cost for starting up businesses, to my own opinion. And also some salient points can be noted here in the CAMA with regards the removal of the statutory declaration of compliance. Prior to now, in the old CAMA, you must have a lawyer who must do a statutory declaration of compliance before a notary public or commissioner of oaths. But this has been dispensed with by saying that a promoter of a company or an applicant can do this on his own, thereby cutting costs for applicants, therefore easing cost and easing the doing of business, if I should say so myself. Also, the creation of limited liability partnerships, giving partnerships an opportunity to be clothed with the corporate personality, has also encouraged entrepreneurs and encourage startups and also encourage people who intend to do business. And the foreigners who are registered as limited liability companies can also come here and register as limited liability companies here. So I can say that with the various entrenchments in CAMA, even if in implementation it might be quite difficult, but it's a step in the right direction. Yeah, I would say so.
Thank you very much, Mr. Oshane, for treading light on that issue. And then from what we said, and in addition to Mr. Soje's contribution, there appears to be quite a lot of innovative additions to CAMA in terms of reduction in cost, in terms of operation, and in terms of making it very easy for entrepreneurs, businessmen, and all that to be able to access the services. I want to come to may I from our audience that one of our panelists who was having technical issues where we are doing introduction, Dr. Sobai is on now. Dr. Sobai, you're welcome to this session. Dr. Sobai, okay, let's continue. So I want to go to Blessing. Mr. Blessing, we've heard so much about the provision and innovations that this has shown up. Which provision introduced by CAMA can be applauded as a provision for our digital age? Because we have the CAMA operated over 30 years. A lot has happened in the business landscape, and all that, a lot of technology has developed and all that to drive these processes. So I want to ask you, Mr. President, which provision introduced by CAMA can be applauded as innovative for our digital age? And how will this innovation enhance the Nigerian business environment or facilitate effective corporate administration? Mr. Blessing.
Thank you very much, Mr. Moderator. Your question has two limbs. The first of two relates to identifying sections of the Act that have embraced or incorporated the use of technology into existing processes and procedures with the view to improving the efficiency index or factor of the Act. This is because you use the word digital age, which I understand to mean age of technology. And then the second limb of your question seeks to identify how that incorporated technology embraces or enhances the Nigerian business space and how it promotes effective corporate administration. In this context, I would want to believe that corporate administration is used in its broadest sense to mean the performance of regulated activities by companies under the Act. Okay, so thank you. Now, to my mind, the first section in CAMA that has earned my loudest applause is section 860 of the Act. This section is the enabling provision under which the Act introduces us to the concept of electronic documentation or e-filing, as it is now called under our company law practice. Section 860 actually provides that any document required to be filed with the Commission for Registration may be filed electronically. The implication of this provision is huge because potentially it has provided a more efficient means formally interfacing with the Commission on matters of regulation. Thus, to incorporate a company now in Nigeria or to file every other thing required to be filed under the Act, such as change of name, increase in share capital, amendment of memorandum of articles of association, and all matters connected therewith can be processed electronically. Now, looking at it from the point of view of implementation, a ready example where we can find this application is in the case of incorporation of companies. As Dr. Soji has said, one of the key indices or parameters used by the World Bank in assessing the ease of doing business in countries around the world is the ease of incorporation of a company. And a key indicator or indicators under this parameter would include, for instance, the number of documents that are required to achieve incorporation. Okay, that is procedurally. It looks at number of documents required, and then we look at time, which is usually measured in number of days, and then the cost of incorporation that relates to or is measured as a percentage of per capita income, and then the last is, the share capital, which is also measured as a percentage of per capita income. Now, if you look at our situation in Nigeria today, before CAMA, we used to have a rather locomotive process where to incorporate a company, you have to go to CAC and buy incorporation form. Over time, there was an upgrade of that process. We now started having some forms that could be printed from your computers remotely and then filled. and then you go to CAC, you pay a minimal fee. All of that has improved. Today, to incorporate a company, theoretically, all you need to do is you start with application for availability and reservation of name. Section 31 of CAMA has made it possible that in addition to sending an application manually or hard copy, you could actually apply for an incorporation of a company, the availability of a company electronically. So subject to your payment of the fees for application, a name, when available, can be reserved for you to use in 60 days as allowed by the procedure. Now, after that, what is the expectation? The applicant picks a form CAC 1.1, which is another electronically generated form. This form, in effect, collapses into one all previous standalone documents that form part of the incorporation document. So in that particular form, before now, you would have your form CAC2, which was dedicated to the promoters or the shareholders of the company, your form CAC 2.1 that takes care of the registered address of the particulars of the secretary of the company, CAC 3 for registered address, 7 for particulars of first directors. Now with your form CAC 1.1, what you now have in terms of document management is you have one form that is segmented into about 5 sections. The first of 5 dedicated to the registered address of the company, that is Part A or Section A. Section B dedicated to the authorized share capital. Section C to the directors. D, like that, statement of compliance or declaration of compliance, and all of that compressed into one document. Now, the benefit of utilizing this document is that you print electronically. You can, as a matter of fact, fill out the form, and subject to your ability to get the required signatures from directors and persons who have to sign, you can actually make payment for incorporations remotely and electronically wire this form and documents scanned evidencing the identities of your directors, maybe international passport, driver's license, or any other form of valid identification, can be scanned to the CAC to commence the incorporation process. Now, I understand the concern that my brother Soji has raised, which is a very valid one, that there needs to be a point where theory and practice meet. But theoretically, the whole idea with this is that it truncates the time, because by the time it is sent electronically, you just start waiting until the certificate of incorporation is prepared by the commission, and then you are notified or your agent is notified. Then the only time you are required to provide documents, hard copies of documents, is when you are to retrieve your certificate. You now surrender such documents that you have prepared, hard copies, and scanned. So that is the point of exchange. Lord will guarantee that the process of incorporation post availability of name can commence on a day, filling the form, having everybody sign on a day. And then, well, subject to how much time the commission would dedicate to getting the certificate or handling the incorporation process, it should be within an appreciable number of managed days. And the other one, which I think technology has put high on that CAMA, relates to authentication of documents. Authentication of documents is covered under section 101 of CAMA. This section not only identifies those who under the company or the under CAMA has in the company to authenticate documents, such as the director, secretary, and any other person authorized under the provisions of the Act, also made a very wonderful introduction saying that electronic signatures are permissible. It's a big boost for men of business, because we have come to see that in more cases than one, there is need to close cross-border transactions, and oftentimes we don't have directors or officers of the company congregated at one point. So if we are allowed to append electronic signatures to documents, there is a cost-saving advantage, the time-saving advantage, the cost-saving advantage of transmitting documents via courier to a director who perhaps is offshore, so that the transaction does not suffer, okay? Like I said, section 175, subsection 1 which makes it mandatory for transfer of companies' shares to be by instrument of transfer, recognizes that instrument of transfer includes electronic instrument of transfer. Thus, an instrument of transfer can be executed electronically, both by the transferor and the transferee, signing the electronically generated form from different locations and transmitting same, even electronically, to the company, with an accompanying electronic application for approval of the share transfer by the transferor to the company. In addition to that, Section 176 of CAMA now provides that that the conventional share transfer register, in addition to that, companies can now keep electronic share transfer registers. This obviates the need to keep bound books, bound volumes that are, in a manner of speaking, somewhat difficult to manage, because we know how difficult it comes when the changes are effected by the board, and then you would have to go back and make amendments and all of that. Many practitioners have difficulties maintaining the manual register, but with the electronic register, its management and updating is easier to control. Added to that is the unique introduction under Section 181, subsection 1, where the use of electronic share certificates is recognized. Section 181, subsection 1 of CAMA is that enabling provision that makes provision for transfer of shares of transfer of a transferor share who he proposes to transfer only a part or a portion of his shares. The practice under the old law is that if a transferor proposes to transfer, bottom line of Section 181 is that it allows companies to issue electronic share certificates. So under transactions relating to companies' shares, we have introduced the use of share transfer forms that are electronically generated, share transfers that can be registered in the company's electronic register of share transfers under Section 176, and then 181 now says the company can issue electronic share certificates. Now, moving beyond that, another area where there is robust intervention through the application of technology is in the holding of company meetings, specifically meetings of private companies. Section or e-meetings, as we now call them, is permissible. As a corollary to this is that if you can hold an e-meeting, then e-voting and all matters connected therewith, subject to the regulation of the Articles and Memorandum of Association of the company, is permissible under 148 and 149 of CAMA. Okay? Now, section. Can you hear me?
So much in terms of technology, so much in terms of the innovation around applying the digital framework to CAMA to make it easy, both practitioners, both users, and both for the regulatory authorities to be able to ensure that the ease of doing business, not just by words of mouth, the application is one. There's so much, like Sophia said, about the theory, the relationship between theory and practice. To get to that, I want to take the opportunity to introduce one of our panelists who was having technical issues joining us, Dr. Pedro Subai, a senior lecturer in law on the Niger Delta University. Dr. Subai, if you're hearing us, please say hello to the audience. Welcome.
Hello, everyone.
Okay, I'll get to you, Doctor. But I want to quickly move on to ask this of Mrs. Omoshade. The CAMA 2020 legislation, one of the innovations, talked about the exemption of small companies having a turnover of 2 million to 150 million and a net assets of 1 million to 60 million for appointing company secretaries. Is it possible for a small company to be run effectively without the company secretary? Considering that sound corporate governance is the facilitator for growth and profitability. Almost a day, I want to take on that. And then the doctor can come in after you unpacked.
Okay, thank you, Sir Sebastian, for that question. I believe your question is, can a small company run effectively without the presence of a secretary, and how does he ensure profitability? Okay. From what you said, the figures you stated, that falls within a small company. We have earlier said that, okay, one of the objectives of CAMA 2020 is to ensure ease of doing business and also ensure that this regulatory framework is in line with what the best practices in other climes. And by entrenching this legislation that small companies are not mandated to appoint secretaries, this is a quite tricky legislation. So first of all, I'd like to explain what a small company is, because there's a lot of confusion as to what a small company is with regards to whether it's a private company as well. A small company by virtue of section 394, a company that has an annual turnover of less than 120 million in the financial year and the preceding financial year, and its asset, the net value of its assets doesn't exceed 60 million. It's also a small company, is a private company. It doesn't enjoy alien participation, and it doesn't. There's no government participation as well. So there's this contention that this provision in CAMA has eliminated the obligation for private companies to appoint secretaries. But this is not true. A small company is a private company, but a private company, it's not necessarily a small company. I'll say that again. A small company is a private company, but a private company is not necessarily a small company. The small company is not a permanent status. It's just, I will believe it's a financial stage of a company, because companies intend to reach profitability and growth, expect to have turnovers higher than this in the future. And private companies, there are several private companies in Nigeria like Bank, NLNG, and EcoBank. These are private companies, but you cannot say they are small companies. So they cannot be obligated, mandated, or given the option of not appointing a secretary. So now I would like to explain who a secretary is. Who is a secretary? Why is his or her presence so important in an organization? By virtue of Section 332 of CAMA, it stated the qualifications that a secretary must possess to be able to be operating in the company. First of all, it must be a member of ICSAN, must be a legal practitioner under the Legal Practitioners Act, must be an accountant regulated by the accounting body. Also, it must be at least if for a public company 5 years prior to getting such appointments, 3 years out of the 5 it must practice as a secretary. So what I'm trying to say here is the position of a secretary is not just a mere facade. A secretary is someone that is important to an organization. If he or she has an extensive authority, it's not just a mere clerk, it's someone that has extensive duties. So this provision, by stating that small companies should be exempted from appointing secretaries, I don't quite agree with it, because the duties of a secretary cannot be exchanged. For example, the secretary is the compliance officer of the company. He or she is the person who is the conscience of the company. He sits in the meetings and directions to meetings. Also, proper returns. The secretary ensures that proper returns are made to the CC as per annual returns and any other changes that are made in the company. In as much as small companies are not mandated to have secretaries, they too are to file annual returns by virtue of the 8th schedule and by virtue of section 417 of the CAMA. They are mandated to file annual returns, and that is one of the major duties of a secretary. So dispensing with the right to have a secretary in a small company, I don't think that will ensure a smooth running of the company, because they cannot toy with the position of a secretary. Also, when it's a governance issue, prior to now, the CSC did not have some certain provisions with regards to effective governance. But most professionals get this knowledge from the review of the Code of Corporate Governance by the Federal Reporting Council of Nigeria, or other codes regulating different sectors. A corporate secretary is knowledgeable in these areas. But now, with the inclusion of some of these provisions in CAMA, for example, there's a provision in CAMA that says that the managing director, the CEO. The position of the MD and the CEO cannot be vested in the chairman. These are core and salient provisions that a corporate secretary gives advice to the company on. And even before it was entrenched in the CAMA, a corporate secretary takes steps to advise the company. So I wouldn't say that for a company to effectively run, you can dispense with the position of a corporate secretary. And I strongly disagree with, even if it's a small company having a threshold of about 120 million. I know that the main aim of CAMA is to reduce entry-level barriers and to ensure the ease of business. There are some certain factors that cannot be dispensed with. I would say this: why dispense with something you would do later, and dispense with it now, so you would do it later? For companies who intend to have commercial profitability in future, why wait till you exceed that threshold before you appoint a secretary? So it's for an effective running of a company, I think is mandatory, and this provision, I don't quite agree with it. So I don't think it can run effectively without a corporate secretary.
Thank you very much for that very input into this discussion. What we learned is that the corporate secretary is indispensable. I will ask Dr. Suba to weigh in this, and then after we go back to Mr. President on the issue of technology. But Doctor, what is your take on the issue of company secretaries for say a small company and all the exemptions and all the talk about threshold and what's your take?
Good to be here once again. What I just want to start by adding is that the law has actually not dispensed with the need for these small companies to have secretaries. What the law has done is that it has removed the mandatoriness. In the past, every company was required to have a company secretary, irrespective of whether it was small or big or large. So it was a mandatory requirement under the old section 293. And that is actually quite burdensome for very small companies. Imagine somebody setting up a small business with a turnover of just 500,000 naira, and you now require that person should have a secretary, on his payroll. So what the new law has sought to do is to dispense with making it mandatory. And again, it's important to note that in the past, under the old CAMA, private companies were not mandated to have professionals as secretaries. So for a small private company in the past, we could just appoint for public companies that the requirement for professionals was, made mandatory. And that same requirement, thankfully, was retained in the new law. But what the new law has now done is to say it is no longer mandatory for a small company to have a secretary. But like my colleague just pointed out, it's still important for small companies, particularly those ones that are seriously into business, to recognize that a secretary is very, very essential. A secretary, like she said, could function as a compliance officer, advise the company, particularly with respect to corporate governance, while also carrying out administrative, sometimes function also as an accountant or a legal advisor and all that. So the company secretary has been recognized even by the courts of our land as an officer of the company. Wherever a company has a secretary, that secretary is a significant officer of the company. So even though that mandatoriness has been removed, it is still in the interest of companies that are seriously into business, appoint secretaries. For what you call old companies, portfolio companies, one-man businesses that are being from the kitchen, parlor, removing that requirement for a secretary, I think has added to the ease of doing business. That is what I want to add.
Yeah, thank you very much. I stopped at the point where I talked about the electronic e-meetings and e-voting, and then also the fact that the CAMA under Section 244 subsection 3 also allows for registered address or addresses of shareholders to be given electronically, because if the shareholder provides his email address, it can, for all legal or practical or correspondence purposes, be used as his registered address. So that has the advantage of creating, the speed required sending notices such as notice of general meetings and all such additional correspondence to the shareholder that the company is minded to make. Another aspect where the deployment of technology has heightened the value of CAMA relates to retention of records, accounting records, and other records that companies are required to maintain. CAMA provides that accounting records be kept electronically. However, it is the responsibility of the company to ensure the security of both hardware and software that is deployed in data preservation or protection. This, I believe, is section 375 of CAMA. Then a final stroke when it comes to technology, which is really, really significant, comes to admissibility of evidence as we know it to be. This you can find under section 860, subsections 2 and 3, and section 861, subsection 2 and 3. The beauty of the innovation created here is that documents filed electronically with the commission can be certified through copies of this document or certified through extract this document can be issued and are admissible in judicial proceedings in every judicial proceeding for whatever purpose without the need to prove the cause or the identity of person behind its production. There is also the presumption of authenticity as to the validity of the document produced. What that means that it will now introduce to us the culture of CTC, electronic certified true copy. And the impact of this is that it will make justice delivery in our courts as we know it be more efficient or quicker. Important. As Dr. Suji had actually pointed out, of the 10 grounds when it comes to assessing a company's ability to create business ease, a key factor there is enforcement of contracts. How, in what manner has the country deployed its resources to ensuring that there is ease in the enforcement of contracts? Creating the ability to have certified documents quicker, aided in that direction. I remember a matter I was privileged to be part of, where out of a commercial transaction somewhere in Delta, the client who was to pay that were not limited liability company. He had been dealing with the company for 7 years, but just had to throw in that spanner just to ensure that he could win some time. Now we had to apply, we had to apply for CTC of our own certificate of incorporation. It took us about 7 weeks to get the CTC. We could not make any progress in that direction. With the deployment of the electronic CTC mechanism, okay, which raises every valid presumption in favor of the document, can be truncated. The time spent can be truncated. And the question of admissibility is in consonance with the Evidence Act, because even a form of evidence that has made elaborate provision for admissibility in the not too distant future, ready access to public information and changes affecting companies that are under the watch of the CAC. Okay, so essentially these are some of the areas I feel technology impacts on the ease of doing.
That was very insightful. That was very insightful. It appears that there's so much to get in terms of the application of technology in CAMA 2020. And trying to getting back online. Let me ask Mr. Soji. Mr. Soji, Militaria. There are agitations about the discretionary powers granted to the CAC under Section 839 and other relevant provisions bordering on the incorporated trustees under CAMA 2020. Are these allegations well founded or absurd? I would like a response to that, Mr. Soji.
Yeah, thank you once more. Well, to start with respect, I don't think the CAC has any discretion under that section, because essentially the way this section is structured, what my understanding of it is, the CAC shall, before commencing the process that could result, actually the section is captioned suspension of trustees, appointment of interim managers, etc. That's section 839. Now, the beginning part of that section may be said to be somewhat inelegantly drafted, but it doesn't grant discretionary powers to the CAC, in my opinion. The CAC does not issue orders. The CAC under that section, actually, the action of the CAC under that section is guarded considerably, in my opinion. First of all, the CAC shall, before commencing the process that could result in the suspension of trustees, first gather reasonable evidence that can stand up to scrutiny in court. Secondly, the CAC must secure the approval of the Minister of Industry and Commerce before applying to court. The court has to be satisfied by evidence before the order to suspend the trustees will be made. The court's power to suspend the board of trustees is limited to 12 months. What that means is after 12 months, there could be a reversion. Now, as a side note, the power to petition the court for this order can also be exercised by 20% of the members. So it's either the CAC on its own, based on verifiable and convincing evidence, can apply, and what the consequences, likely consequences of that court order will be. The petition to the effect must show the following: mismanagement or misconduct in the management of the association, that it is necessary or desirable for the purpose of protecting the property of the association or securing a proper application of the property towards the objects of the association, and also for public interest. Also, if the affairs of the association is being run fraudulently. So following these guidelines, I do not think at all the CAC has a discretion. And to that extent, agitations are unfounded, in my respectful view.
Thank you very much.
Can I come in here?
If I can come in, Sir Sebastian, with regards to this particular question. One thing that's prominent in Nigeria, especially with legislations, is that they usually are an offshoot of what is obtainable in other countries. For example, this provision in 839 in CAMA is similar to Section 76 of the Charities Act 2011 of UK. Yeah. And it's almost verbatim with what is stated here. But it states in Section 76 that a warning can be given to this incorporated trustee or this body that is carrying any form of misconduct or mismanagement, sort of like a pre-action or pre-action notice, if I put it like that, stated there. But this, our CAMA did not provide for that. I believe that if that was entrenched in CAMA, it would save us a lot from the uproar that is going on around about this provision. So if a warning is being sent to this trustees to put their acts in order before a petition can be brought to the court, it would have made a lot of difference in this legislation. I just wanted to put it out there.
Can I also say something?
Regarding this section, we heard from Mosadi and what she said about similar provisions and other jurisdictions and all that. I want to ask you, this question, you could take it and all that or not. Are there underlying political or religious undertone in the amendments? Do you think there are political or religious undertone? Because it appears that certain groups and certain type of organizations are pushing for this not to be in operation. So what's your take on that?
Yeah. Well, I think yes, indeed. A lot of political or religious imputations can be made, because essentially these parts, now part F, which used to be the part C, actually covers the registration of incorporated trustees and the regulations thereof. And most religious organizations are registered under that part. Political organizations, and a lot of, charity organizations, social organizations are registered under that part. And really, taken from what Obosede has just said, and the way the law is couched. First of all, I think there's some mischief in the social aspect, in the social dissemination of information in that respect. Also, a lot of the human rights organizations are registered under that section. And what actually the amendments are looking to do is to bring about transparency and accountability. Now, is it that the agitation is towards a refusal to be accountable or a refusal to be transparent? The religious organizations are claiming that there's an attempt to take over churches, and others are saying it's not only churches. We should also remember that even political parties are registered under this section, and there are laws to say what the political parties should spend only certain amounts of money for elections and so on. So this will create avenues for better accountability. And really, the way it's structured, you would know that there's a history of some sort, of some degree of lack of transparency. Like you have things like those government-owned, non-government organizations, mainly owned by first ladies, a lot of government patronage, but the money is not really accounted for. So this kind of legislations actually will check a lot of that. And we just hope there's no abuse, because presently there are other mandatory requirements that are not even in the law. So that actually creates room for suspicion. We have a requirement by the CAC, which is not really in the law, to say you must come for this RG's consent and pay some money before you even go for availability and reservation. Really, that creates suspicion. And I think this legislation actually, a child, born during the pandemic, I'm sure with time, with application, I know very well there's going to be a lot of litigation, and I'm sure those things will be resolved. But whether there's the politicians will be agitated, the religious bodies will be agitated. It's typical of the Nigerian environment. But I think the legislation is commendable, and we should amend and adjust as the agitations continue. That's my humble opinion.
Thank you very much, Mr. Soji, for backing. That's very instructive. I will come to Dr. Sumai. Section 705. That's a topical issue too. It has to do with the recognition of a private association called the Business Recovery and Solvency Practitioners Association of Nigeria to certify insolvency practitioners. In your considered opinion, is this unusual? And should we be worried? How does it affect the ease of doing business, doctor, to have the private as part of the new CAMA?
Thank you very much. Actually, insolvency practice is a very, very technical aspect of law, because it has to do with troubled companies. When a company is troubled financially, an insolvency practitioner could be appointed either as a liquidator, receiver, administrator, as the case may be, to secure the interests of the creditors, as well as the members, and then of the company, then finally the public, and even the employees of the company. So because of how technical and delicate this aspect of the law is, it has become quite imperative that the persons who act as administrators and insolvency practitioners of companies should also be subjected to some form of regulation. So the practice now in several developed countries is to have associations, insolvency practitioners associations, which set the standards, first of all, for entry. So not everybody should be able to act as an insolvency practitioner. It should be able to have some level of expertise. And secondly, such a person should be subjected to some codes and rules and regulations as well. So what you now have in New Zealand, in South Africa, in Hong Kong, in the UK, is that they all have associations of insolvency practitioners. And so BRIPAN itself is, to my mind, a welcome development. The only challenge there is that it appears not to have been established by any law. I want to believe that it was provided for in CAMA in anticipation of maybe a subsequent enactment of a law to give formal establishment to BRIPAN. So I think there is need for the National Assembly to enact this law, setting the scope for BRIPAN and outlining their modus of operandi. But again, it's important that I should point out that even though BRIPAN does not have any legal life, it does not own its existence to any particular statute, that is actually not the first time such a thing is happening. We have the Nigerian Stock Exchange and the Department of Petroleum Resources, the Nigerian Bar Association. These are bodies that are not established by law, but they have also been recognized in a number of statutes. The DPRO is the principal regulator of the petroleum industry in Nigeria, but it does not derive its life from any law, even though it is recognized in several statutes. The same with the MPA, the same with the Nigerian Stock Exchange. So it's not totally out of place that CAMA is making mention of BRIPAN, but what I think they should do is to tidy it up by enacting a law, establishing BRIPAN, and setting out the scope of its operations, limits on the powers of the person's administrative body, and all that.
Thank you very much, Doctor. Do you agree with the doctor's exposition on this matter?
Sorry, Sir Sebastian, I didn't get that.
Do you agree with doctor's position on doctor is saying that it's not unusual to have the private organization, the regulatory body entrenched in the document such as CAMA? Do you agree?
Well, to some extent, I would say I agree. But the question, I think, is whether we should be worried that they've been given the power to appoint insolvency practitioners. If we, the CAMA 2020 has been inclined to taking steps to save companies and ensure business rescue as opposed to outrightly ensuring liquidation of companies. And it has done that in several of its provisions by creating provision for voluntary arrangements, several corporate restructuring options such as voluntary arrangements, netting, and then administrations. And it states that in CAMA, nominees who are appointed to carry out these activities must be they must be insolvency practitioners. So the contention here, which I feel, is whether BRIPAN is the only recognized body to be given recognitions for appointment of insolvency practitioners. First of all, who is BRIPAN? BRIPAN is a professional body termed the Business Recovery and Insolvency Practitioners Association of Nigeria. Their main aim, as we see, is to educate and certify insolvency practitioners. And they've taken a lot of steps to ensure legislative reform in the insolvency practice. So hence, I guess their recognition in this CAMA 2020. But now, by virtue of Section 705, it is stated that the requirements of who should practice as an insolvency practitioners. It says that degree holders in accounting or law, insolvency practitioners recognized by BRIPAN, and also those who have post-qualification experience of 5 years in insolvency matters. But the contention is that most people, it's really, there's the contention rather that it's most times it's only insolvency professional practitioners certified by BRIPAN. But the entrenchment in this CAMA by saying other recognized professional bodies. Hello, can you hear me?
Yes,
saying other recognized professional bodies also clears this worry of whether we should be worried, because by saying other recognized professional body gives way for lawyers and accountants who fall under this threshold, who have met the requirements of Section 705 to be able to practice as insolvency practitioners. So I would say that this is the inclusion of BRIPAN, like Doctor said. They have not been outrightly recognized, but I think this is a means of recognizing them as insolvency practitioners. But that does not negate the fact that other recognized professional bodies, like members of MBA, can also act as insolvency practitioners. I think this is just to ensure that the insolvency practice is more regulated. By virtue of Section 706, it stated that the requirements of other professional bodies who can practice as insolvency practitioners. They say they must be fit and proper. They must qualify as insolvency practitioner according to this act, and also they must have the educational requirement, experience, and also training. So I would say in this, with regard to your question, whether we should be worried, I don't think we should be worried because other bodies can also practice. And also whether it has aided the ease of doing business. I said something when I started by stating that CAMA has been inclined to ensure business rescue as of structuring mechanisms. By doing this, I think this will ease the doing of business and ensures companies stay afloat instead of outrightly going into insolvency. So that's my take on this question from what I gathered from your first question.
Okay, thank you.
I would like to make a comment if it's okay.
Yeah.
Okay.
Hello, sir.
Yes, listen.
May I also? Yes, yes. Sorry, sir. I was hoping you permit me to say a thing or two about the BRIPAN.
We are out of time, but go ahead, make it quick.
Very quickly. With deference to my colleague, I think it is a bit presumptuous of us to say that BRIPAN is not an association registered under the law. Yes, because I would want to say I believe it is a company limited by guarantee, or well, it's registered as association or an NGO under CAMA. Now, like Dr. Subai had said, falls into the league of the Nigerian Stock Exchange. Under the law, these are entities that are called self-regulating organizations, or SRO. What they do is that they constitute themselves, come together to pursue purposes that are society-driven. Okay? Like the Nigerian Stock Exchange within the financial sector is intended to protect financial investors, securities market, and all of that. But it is a company limited by guarantee, a private company limited by guarantee. It is self-regulatory because it's the standard, best practices for all practitioners to operate within the sector. And it all makes rules and procedures that will call for even discipline of members. BRIPAN falls into this league. Another entity that falls into this league is, for instance, the Nigerian Society of Engineers. Go to their website. The Nigerian Society of Engineers is a company limited by guarantee, self-regulatory, regulating the practice of professionals, engineers of by whatever name called in Nigeria. Okay, they have provisions for clean legal education, clean professional education, and such other packages that would ensure that they keep at par in their practice and maintain the best ethical standards. BRIPAN has created that for itself by dedicating its entire arsenal to handling insolvency and business recovery practice. What it has done, it has been to incorporate as a company limited by guarantee and to dedicate itself to creating standards, minimum basic requirements, and prescriptions of best practices for its members. They have done so much in terms of legislative proposals, even to the National Assembly, to give them some kind of legal backup, not for themselves, because they don't need the law to practice as insolvency practitioners. The fact that they are mentioned in CAMA, the recognition in CAMA alone, puts them at the same pedestal as their peers like the Nigerian Stock Exchange, which does not require government's fiat by way of charter or charge, as you would have maybe the Institute of Chartered Accountants, ICSAN. They don't need a government charter. They are self-regulatory, operating outside the ambit of the law, but subject to government's control to the extent that government can make regulations that, when applied to them, because they are entities, laws that government can make. And government can delegate some of its oversight functions to entities that are self-regulated. So in this case, what I see happening here clearly is the CAC recognizing as the body that engagement of people who must meet a minimum basic qualification to practice as insolvency and business recovery practitioners. Now, like the lady has said, the wonderful lady has said, there are other standards to follow. The anxiety that people have expressed regarding whether or not you must be a member of BRIPAM before you can practice, I think it's an anxiety that is born out of the fact that they have not taken time to study the structures. Okay, now BRIPAM is there. Before BRIPAM, we had insolvency practitioners. And CAMA has made even the leeway by saying this and that, and such other organizations or associations that the commission recognizes. So it's is BRIPAM a private, quote, company or organization? The answer is yes. But to what purpose? Is it for profit? It is not for profit. Is it a self-regulating organization that is intended to capture and instill discipline in a particular profession or field of engagement? The answer is yes. Can it be the leader in that area of practice of that particular profession? The answer is yes. Can government delegate some of its functions? For instance, in this case, pre-qualification for practice functions to it. The answer is yes. Is it an arm or agent of government? The answer is no. So these are the little relationships that we need to understand. BRIPAM has come as a very quiet entity. It has only become loud because it finds itself under section 705 of CAMA. I was amazed when I saw it, and I recall speaking with Dr. Subai about it, which even informed this inquiry that we are making. But the truth of the matter is that BRIPAM is ably qualified to assume the role and enjoy the recognition that it is now receiving from the CAC or the commission, such that if push comes to shove and you propose to take it to court, I do not think the chances of success in that area will be fair. You know, that's all I have to say, sir.
Thank you very much, Mr. President, for that very wonderful insight perspective on BRIPAM. The pros and cons of its inclusion will be a topic for another day. Right now, we are running out of time. We're going to wrap up this section in the next 1 or 2 minutes. But quickly, I would like to ask Dr. Subai, quickly, all these amendments, the amendments in the CAMA is imperative for entrepreneurs to seek alternative business forms, considering all the different new innovations and all the technological advancements in the legislation. What is it? Entrepreneurs able, willing to seek alternative forms of business with all this? Doctor.
Okay, thank you for that. We have always had alternative forms, alternative business forms, even before, even acting side by side with CAMA. We've always had the unincorporated form of business. We've always had the partnership, which has been regulated at state level. You know, so for example, Lagos State had the limited liability partnership law. Rivers State has always had a partnership law. Most of the states in Nigeria have always had partnership law. So these alternatives have always been there. You know, the upon states, the various states have authority on private businesses. And that is why incorporation has always been conferred by a law of the National Assembly. You know, so what CAMA has done now, in a sense, in a certain sense, it has created a room for entrepreneurs, particularly small entrepreneurs, who may be wary or cautious or unwilling to subject themselves to the regulatory obligations and burdens of the law. For such persons, they can now begin to look inwards. You know, they don't necessarily, because if you, as a lawyer in practice, when you talk to a lot of people who are looking for incorporation, they do not even know the reason why they need to incorporate their businesses. Most businesses that are incorporated actually need not be incorporated. Many persons do not understand limitity and the so many benefits that come with incorporation before they seek incorporation. Rather, they seek it ignorantly, they seek it as a matter of maybe acquisition of status and all that. You know, so what I'm trying to say is that the new law has now brought in more obligations and burdens. For example, if you look at, we talk about the ease of doing business, but if you look at the provisions relating to even incorporation, to my mind, it's more difficult now than even before. You know, when you look at the documents you now have to file with the Corporate Affairs Commission and all that. So lawyers and advisors can start advising their clients to look inwards. That is one side of it. For persons who really, really want to take their business far, incorporation remains the game changer. Incorporation remains the optimal choice. You know, and for such persons, you can't actually do away with incorporating your business or acquiring corporate personality. And that is what this law has sought to do. In Part B, we now have the company, but in Part D, we now have limited liability partnership, which again has a separate legal existence and its advantages and benefits which partnership law ordinarily cannot confer at state level. You know, even though it can confer limited liability to some extent, it cannot confer what is referred to from the assets of the members who come together to organize another form of business. So, to my mind, continue to work with the Companies and Allied Matters Act, and entrepreneurs should continue to operate under that head.
All right, thank you very much, Doctor, for that very wonderful and beautiful insight into that aspect of our conversation today. We have come to the end of this section. We're going to take the next section immediately, which is Q&A. We have the question projected on the screen. And then, okay, this question from our audience is: it seems ICSAN qualification is yet to be recognized in almost all sectors of economy. What is the employability prospect for those who have or intend to have ICSAN professional qualification? That's one aspect. What are the relationship of the qualification with other professional qualifications, such as ICANN? Soji, would you like to take that?
Sorry, please. This.
What about participants? I want to read it again. Are you seeing it?
Okay. The question actually goes to the employability. Yeah. The employability and the relationship between ICSAN and, indeed, you know, your qualification as a member of the ICSAN actually puts you it puts you in a position where, like the name goes, Institute of Chartered Secretaries and Administrators. If an organization requires a chartered secretary, you can step forward. If an organization requires a chartered administrator, you can step forward. And if an organization requires a combination of all of it, you can step forward. And really, it provides you with the kind of tool, even when you're not inside an organization. If you provide support service, support professional service, either as an accountant or as a lawyer or just as a chartered secretary or a member of the institute, what it does for you is they can come to you based on what kind of arrangement you have. If you're an external advisor, you can have a retainer and they can bring any part of the company's work to you. Interestingly, chartered secretaries were one of the most useful for this pandemic because for the setting up of business sustainability plans, for the setting up of what consequences there are to contracts and all, they were the people that were called upon during the pandemic. So you can see how much resilience they provided by their services to businesses. That's for employability. If you want to be employed in-house, of course, you're not coming in as another company secretary. You're coming in there as a chartered secretary. And they call you a chartered secretary. It's not that you're limited to, you will see that you understand the admin structure, you understand the relationships between the company and external stakeholders at every level. So you come in with such a robust package. You, first of all, if you're a lawyer and you're taken in as a company secretary, you're a lawyer as a company secretary. If you're taken in as a member of the institute into the company as a secretary, you come in there, you come in over and above what an ordinary lawyer would have. Also, you come in there with more than what an accountant would have. So that's for employability. Now, even to engage your services, even as a member of a board, you come in with a very robust background that you can relate to management, you can relate to shareholders, you can generally conduct the affairs of the company at any level. That's for employability. Now, relationship of the qualification with other professional qualifications such as ICANN. Yes, you're chartered. If you're a chartered accountant as a member of ICANN, you too are chartered as a member of ICSAN. And in terms of parallels, most times they are ranked about the same, if not more, for the chartered secretary in a lot of times, because the chartered secretary's role is particularly so strategic. There are chartered secretaries they answer to the board. They answer mainly to the board. There are chartered accountants that answer to the chief accountant. They don't answer to the board. But chartered secretaries typically answer to the board. So I think that sheds light, except there's something else somebody else has to add.
Thank you very much. Participants, at this point, if you have a question or comment, kindly indicate by raising your hand, and then we will give you the opportunity to ask your question live. And then once you indicate, you can unmute yourself and ask your question. You can direct it to any particular panelist, or we will deal with it accordingly. Nosa Ibinaweka, please unmute yourself and ask your question. Nosa Ibinaweka.
Yes, thank you very much, the moderator, and then the team of panelists that we have. My question, but it's not to a particular person. It's a general one, and I think anyone can respond. Talking about the ease of doing business, electronic processing of documents. We mentioned something like acceptance of electronic signature to documents. I want to find out, there could be problems that could arise from that. What are the safeguards in place in the same law to be able to ensure that this is not exploited to defraud?
Okay, thank you. Okay, Blessing, like to try to take it. Hello.
Hello.
Blessing.
Yes, please. Sorry, I'm having serious interference at my end.
Oh, so I guess you didn't get the question right.
Please, what can you repeat the question for me?
No, sir.
Yes, I talking about electronic signature to documents. Are there safeguards in place to process to guard against fraud?
If there are safeguards in place to guard against fraud, well,
yes, by CAC.
The truth of the matter is that the application of the these electronic signatures by the enactment in CAMA is left to the prerogative of the company. The CAC will not let you or will not tell you how you apply the signatures. Every company is obliged, and this is something some of us have been doing over the years. Every company is obliged to put in place a system or structure that would ensure that it can easily apply electronic signature to documents to guarantee the security of the process and the approval lines in place. So if, for instance, a director has provided an electronic signature, there is supposed to be an approving line. By that I mean a dedicated officer who has to perhaps interface with the director to place a request on the need to append a signature. The director will have to see the document and give express approval before that is done. Now, the truth of the matter is, when it comes to electronic signature, the custody of that signature will either be with the director himself or one other designated officer who has to explain how such signature got onto a third party's document without his own approval. So it's a question of, it will fall essentially to the prerogative of each company to put in place systems and structures that will guarantee the security of the process. Because whether you like it or not, if a signature goes out there and it is apparently formal relative to the actual signature of the director, it can pass off as the signature of the director. But then again, remember, even now that we are doing signature by longhand, signatures are still being forged. So it's a question of each company taking steps to ensure that the system by means of which electronic signature is administered is protected. It is not something that CAC can do for you. And the Act did not give CAC that allowance to do it.
Thank you very much. I can see no hand at this point. It's been a very exciting session. I would like to our panelists 30 seconds. 30 seconds, Soji. 30 seconds, what's your takeaway?
Yeah, thank you very much, Mr. Moderator. Just to round off, I would like to add that CAMA 2020 is actually a child born in crisis. I do not think that it would have been wise that for how long we waited for an amendment of CAMA for us to make. We're still struggling. You can see that even as at now, there are so many restrictions at the CAC, and the promise is that all of that will be removed, and the application and the implementation of the Act will flow properly. We hope that as the agitations continue, and if it is brought forward properly, at the end of the day, we petitioners and the general public will be better for it. I think all in all, it's a fantastic law. We wait for petition.
Thank you very much. Omosade. Thank you. Omosade, seconds.
Okay. I would conclude by saying that CAMA 2020, its objectives has made provision for the ease of doing business, even if there are still some impediments. I believe that it has taken steps to be in tandem with what is expected in other climes. And also it has ensured transparency in the board by some of its provisions. So I think it's a step in the right direction. Yes, more needs to be done. Yes, there are a lot of problems, but at least something was done. So it's a step in the right direction. Thank you.
Dr.
Yes, what I want to just add is from the aspect of CAC, we didn't really get to talk about it, but CAC is going to play very pivotal and strategic roles in this act is going to succeed. So I think one particularly now that we are going online significantly, and I also suggest that they should significantly decentralize their giving function regulatory powers to be able to begin to carry out effective monitoring of companies. They should move from functioning as registries that collect annual returns and filing fees, and now begin to effect. Thank you.
Thank you very much. Blessing and accounts.
Yes, thank you so much. I believe the introduction of the 2020 Act is a welcome one. It is still work in progress because it signals the beginning of so many things that need to be in place. Today, we are responding to the code provisions as is. We have not tested them in terms of application. There is work to do. My regret was that we never had the occasion to discuss on a subject, a second limb question you asked regarding the downsides to CAMA. I may have shared some ideas with everybody listening, but in all, it is innovative, it is forward-looking, and it holds a lot of prospects because by the time, from a utilitarian point of view, by the time you assume that lawyers and other professionals are beginning to become commercially disenfranchised, we're having more lawyers and other professionals busy. So at the end of the day, government wins, the professionals win.
Thank you very much. Thank you very much, Mr. Blessing. And at this point, I would like to hand over to Mrs. Semi Okoloma to take care of business on the concluding part of this session.
CAMA 2020 quiz was sent out to registered participants. The quiz was sent out yesterday on the 23rd of September. It was open for 12 hours. So basically, it was intended to test the knowledge of our participants on the principal parts of CAMA. The quiz was timed for 4 minutes. Once a participant logs into the quiz, you have to complete it in 4 minutes, otherwise you'll be logged out. So we had a total number of 16 entries for the CAMA quiz. Out of the 16 entries, the benchmark points for winning the prizes that we have set out is 3 points out of 5 points. So for the total of 16 entries, we had 10 entries that had correct answers above 3 points. Then we had 4 entries with 2 points and below, and 2 entries with 0 points. So I'm going to go ahead now to share the list of people who are on our honors list for the CAMA quiz. So we have on the very first number here, we have Inkotaria Tengo. The person came out 5 points out of all 5. That means he or she is a resident CAMA expert. Then we had Halima Omar with 4 points out of 5. We also have Happiness Anthony Ikwe with 4 points out of 5. We have Ine Fubata with 4 points out of 5. We have Toluwashe Olobayo with 3 points out of 5. We have Adewale Adekunle with 3 points out of 5 points. We have Rita Onya with 3 points out of 5 points. We have Sheun Korede, and we also have Matanaya Douglas and Chinelo Nwago. So basically, these are the prize lists that each of these entries have won, having participated in our CAMA quiz for this webinar. The CAMA quiz was brought to us courtesy of Mrs. Iviene Mbano, the Director of Public Prosecutions, Rivers State Ministry of Justice. She's also a member of the Education Committee of the ICSAN Rivers Chapter. So the winners of our CAMA quiz will be receiving their prizes shortly after the webinar. So they'll be on the lookout for the text messages for the airtime and the data alerts. So thank you so much to our 10 lucky winners. We are so grateful that you took out time. We were very vigilant because it was a window of about 12 hours and they were able to get in and participate and they got in the correct answers. We are so grateful for your participation. So at this very point, I want to invite Mrs. Happiness Anthony Ikpe to take us through the vote of thanks. And finally, our chapter chairman, Barrister Emeka Onoha, will take the closing remarks and will be gone for the day. Mrs. Happiness, please.
Hello. Please, can you hear me?
Yes, we can.
Hello. Okay. The President, ICSAN, Institute of Chartered Secretaries and Administrators of Nigeria, ICSAN. The National Council, the Chairman, ICSAN Rivers State Chapter, Barrister Emeka Onoha. The Education Committee of ICSAN Rivers State Chapter, ably led by Celine Okoroma, Mrs. Our distinguished guests, ladies and gentlemen. On behalf of ICSAN Rivers State Chapter, I have the privilege to appreciate our distinguished guests of this August occasion for creating time to attend this webinar. What could we have done without you? Of course, nothing. In a special way, I thank the panelists for doing justice to the theme, CAMA 2020, Innovations, Intrigues, and Downsides. I believe that their horizon must have been broadened. Thank you so much for coming. We are also indebted to our esteemed attendees for actively participating in this insightful webinar. It is an honor to us that you opted to be here. The contributions of ICSAN National Council, Rivers State Chapter, and the Education Committee of Rivers State, who is, of course, we know that they are the organizers, they are the chief cook of today's intellectual dish, were of inestimable value to us. Hello? They were of inestimable value to us, and we say well done. To the moderator and every other person that contributed to the success of this webinar, we say a very big thank you. You will agree with me that it is not actually an easy task to organize a program of this nature, but by the grace of God and our collective efforts, it turned out a big success. We give all glory to God. My appreciation also goes to the organizers of this webinar for finding me worthy to give the vote of thanks. Like proverbial lizard that fell from an iroko tree and praise is, I thank myself for thanking you.
Please, at this point, can we invite Barrister Emeka Onoha, the chapter chairman, to kindly give us some closing remarks so we can dismiss for the day. Thank you so much for your patience.
On behalf of the chapter, let me thank everybody, particularly the panelists, for their time and industry. I urge everyone to look forward to the next edition. While I apologize for all the hitches and assure you that we'll never experience it again, I pray God to bless everyone for coming, and I wish each and every one of us goodbye for another successful webinar. Thank you all, and may God bless us all. Bye-bye, everybody.
Bye-bye.
Thank you.
Bye-bye, everybody.
Hi, everybody. It's an awesome time.
Bye.
Bye, everybody.